Okay, welcome back to the Warrant Committee meeting. I don't know if we're live. That was more than 3 minutes. I apologize. I want to take this moment to introduce the newest member of our committee, Brian Beaupre, to the Board of Selectmen. Two-thirds of the Board of Selectmen, I don't know if you had a chance to meet them earlier, Katie Conlon, Tom Hurley, and your strong town administrator, Anne Marie Fagan. So, at any rate, so we're going to take up Articles 7 and 8, now named, amplified noise and non-conforming dimensions. And for that purpose, we have Emily Innes, Chair of the Planning Board here. We also have a couple of distinguished guests, and including the Director of Planning for the town of Milton, Bill Clark. So, Emily, welcome.
Thank you.
I just want to say, before we get going, thank you for the effort and energy and the process you instituted with the Planning Department to tackle so many subjects, but thank you for not bringing them all to us.
You didn't want 45 pages of zoning to talk about tonight? You know, the Planning Board and the Planning Department spent a lot of time and effort this summer in kicking off this new process, and we appreciate your thank you. I will pass that back to the other members and to the department. But ultimately, when we got to our public hearing last week, it was generally felt that not all of the articles were ready for prime time. We knew we were taking a risk over the summer of trying to get public input when there might be people on vacation. Plus, we were kicking off a brand new process, and we weren't sure how it would be received. So both members of the Planning Board and members of the public who spoke at the public hearing indicated that they felt there was not sufficient participation by the citizens to be able to go forward with these. And, you know, that's fair enough. We took a lot of complex subjects. One thing I know we will be discussing next week when we discuss our process going forward is maybe reducing the number of extremely complex articles we take on at any one time. I've asked the members to come up with their top 3 priorities for going forward for January to be to the Maytown meeting. And then obviously we'll also be starting to look at October of next year, so we don't have quite as compact a process for October 2016. But in all, I think it was worth doing. I think we did introduce a number of subjects that have been hanging out there and start to put some language to what we were trying to do, and we'll go forward with that. But in the meantime, only 2 have survived: amplified music, which is going through as a general bylaw, and non-conforming dimensions, which is a zoning bylaw. And I'll be happy to talk with you tonight about them, and I understand there are some, as you said, distinguished guests who would also like to comment on the non-conforming dimensions. So,
Sure. Lee Michael.
Emily, thanks for coming. I'm glad to see that you're smiling, especially after the last planning board meeting. You alluded to the comments by the public and fellow planning board members, and I agree with you that it was a worthwhile process. I applaud you for taking on such an incredible slate of articles and trying to be proactive. I think a lot of what happens in this town could be a lot more proactive, and I think that you're on the right track. And I was disappointed at the level of comments, both from planning board members and from the public, that bordered on personal attack versus commenting on the process. I think that the process was good. I think you got a ton of feedback from town members, and I think you had a lot of people that weighed in online. I think that you came up with some great new ways of soliciting feedback. And I also think that if the town wants to continue having a fall town meeting during which zoning articles are discussed, and then wants to say that the summer is not an appropriate time to finalize vetting of articles that discuss zoning, that there is something incongruous about the timing of the fall town meeting, because the summer can't be off limits. So I don't like that argument, and I don't accept it, and I think that what you did was fine. I think that the articles in the end weren't ready for prime time, but I didn't appreciate the language that was used. I didn't think it was deserved, and I was sorry for it, and I just wanted to say thank you for your time.
I appreciate that. You know, I was talking with a client the other day, and I said, well, Summer is off limits because summer, and September and October are off limits because you're just getting back into the school year and into the swing of things, and you can't do anything in November and December because holidays, and January and February is snow, and March and April is skiing and the winter and spring vacations, and May is town meeting, and then you're back to summer again. So I think it's a problem that all towns face, is exactly when do you undertake initiatives. But I think we learned a lot and are continuing to learn about how we reach out to people, how we ask them to review sometimes, well, frequently complex and legalese type language, and then how we bring those comments back and move forward with the changes. So I appreciate your words, and we are continuing to learn from the process.
Yeah, I would just like to add that these are difficult subjects, and I think where your process may have fallen a bit short is in time, simply time. You needed more time for peer review and more time for public hearings. And, you know, I mean, you could have had 7 nights of public hearings given the number of articles you were trying to put out there. At any rate, what would you like to tell us about amplified music?
So, as I
Because
said
I can tell
earlier,
you something.
well, I believe you've heard from town council on these, which I have not.
Okay.
So if you have something that you'd like to share, that would be great. It'd be hard for me to comment if you know something I don't.
Okay.
So.
I have not heard town council on
Okay, good.
amplified music.
All right.
I haven't checked my email since about 6 o'clock this evening. So I have heard from the chief of police.
Okay.
Okay. And he's not wild about this article. And this is his main point. First of all, he'd love to give us a detailed response next week. And I think, unfortunately, as soon as we decided that this, or as soon as you decided that this should not be a zoning article, change to the zoning bylaw, but that it should be added as clause number 42 to the police regulations, that day is when we should have been in touch with the police chief, maybe.
Mm-hmm.
At any rate, he says in general we would not support this.
Okay.
It is unenforceable. The article does not address any issues of enforcement or penalty. He goes on to say that the town bylaws under the police regulations, Chapter 6, have all been codified into statutes with penalties long ago, disturbing the peace, littering, traffic offenses, and the like. There is no statute or CMR, which is Code of Massachusetts Regulations, that would address this relative to noise offenses. So how do you judge noise levels or enforce them and have any schedule of penalties? So he doesn't think that the article is, if you're going there, is sufficient. And he'd probably rather not go there because he's not sure what the enforcement mechanism would be. And probably, that's, when you read the article, there's a measurement of 10 decibels, and that's great in theory, but when you're standing there on the scene of the crime, what do you have with you to prove that it's 10 decibels above ambient level? Now, I know that for a variety of reasons, we'd love to have something in the bylaw that addressed noise in the town, especially amplified music. And I know that some residents near Curry have had difficulties with this, and whether or not a town bylaw, whether it was police regulation or in the zoning somehow, could be applied to an educational institution or not is open to question.
Yes,
If it,
I agree.
even if it could not, it would certainly be a standard by which their activity could be measured. But anyway, those are my thoughts on top of the chief's thoughts, which are that this article has problems. So that's where we are on. That's where I am on this. But I didn't hear from town council.
Okay, I would actually like to also hear from town council, because I think you and I both have the same question, probably other members of the warrant committee do as well, as to whether or not it would apply to any educational institution that was playing music at an highly amplified level. To your point on the 10 decibels, the idea is that the user, the person who is amplifying said music, would have to prove that it was no more than 10 decibels above. I think your general effect would be that the police officer would come, say, your music's too loud because I can't hear myself, talk to somebody else on the lot line, turn it down, and they'll say, well, it's no more than 10 decibels above, and somehow measure that? I don't think so. I think effectively they'd have to turn it down. We did have one member of the public come and say that amplified music is, maybe it's a good thing, maybe it's a bad thing, but what we really need is a sound bylaw in Milton, or a noise bylaw in Milton. We don't currently have one of those. State regulations, I believe, restrict noise to 7 a.m. and later, but we as a town don't have anything, and that might not be widely known. And something like that would cover leaf blowers or other things other than music that make noise. So, but the basic effect of this is to, and that's why it's in the police regulations, is that it's enforced by the police coming and telling somebody to turn their music down. And as you say, establishes a standard for amplified music throughout the town. Whether or not that is applicable, as I've said, to educational institutions, we don't know until we get that report back from town council.
So I just want to remind the warrant committee that even though what you see up here is a recommended that the town vote to amend, that we have options.
Yes.
We can recommend that the subject of this matter, of this article, be referred to the planning board for further study.
Mm-hmm.
We can recommend that the town vote no, or we can just write into the warrant that the warrant committee has no recommendation at this time, which means that we will then meet sometime in October before town meeting and take it all up again. And at that point, you probably better come up with something a little more intelligent in the way, by the way of a recommendation and a comment. Anyway, Darnell.
Before we go that route of like not a recommendation at this time, also, what is the realistic probability that we will actually get some language that will be, one, enforceable, and two, pass just general muster? And my biggest concern, because that's what folks who come here before this committee, this 2 years ago almost now, Ted, with the Curry stuff, that this here is going to address their problems and stuff. And, because I think a big portion of this, or the emphasis for this, was centered around that. So I said, what's, Emily, if you're here, you can give us an idea, what's the realistic probability that we will, I like using those words, realistic probability, that we will be able to hammer out something that's going to effectively pass police muster, deal with the Curry issues and stuff by this town meeting, fall town meeting?
So that's a reasonable question. As you know, the planning board has a few things on its plate at the moment.
I understand that.
This is the recommendation that we have voted after our public hearing, which was last Thursday, to send to the warrant committee for your consideration. Without town council's opinion on whether or not this applies to institutions, I can't answer your question as to whether or not this would actively address Curry or any other school that's playing loud music. I think certainly under zoning regulations, there are only 8 things that we can regulate under zoning regulations, and neither sound nor light is one of them. But this is a general bylaw, and how that applies, I don't know, because I am not familiar with how the Dover amendment would work with the general bylaw. And I know that it came up briefly during our public hearing, and we did not have a definitive answer on that, so I can't answer you there.
Police. This
And-
is part of the police.
And this is part of the police regulations. You know, if he feels that it doesn't address issues of enforcement or penalty, we could certainly have another look at it. I'd be happy to take it back to the planning board and ask them to look at it. Obviously, now that it's on the warrant with the original language that we submitted, and at the end of August, and then now here with our recommendation to you, and then whatever you come up with, there's the issue of changing the scope of the article, and adding penalties could potentially be out of scope, so that's something else I would ask town council. Should I make a note of it now? So. But we are meeting next Thursday, and the zoning articles will be on the agenda, so I'd be happy to bring it back if the warrant committee feels that it's necessary or desirable.
Well, I'm not sure that anything we add to this article would make the police happy about issues of enforcement. So we may, my feeling is that we need to know ourselves a lot more about state regulations that could be applied in any situation like this, and also what are the implications of a noise bylaw in the town general bylaw. You know, what implications that means to the educational institutions in town. And we don't know that yet. So practically speaking, because the original question was, practically speaking, can we change this to make it enforceable and satisfy everybody that it ought to go forward, at least for a vote?
Can I add something on the
It could be tough.
enforceability? That was something that we did discuss quite a bit, and there's an issue with the amplified music and having it under zoning, which is enforced by the building inspector, which is amplified music is not normally a problem during the hours that the building inspector is working. But it's usually a problem after normal business hours, and so if you're going to have somebody enforce it, it has to be somebody who is around during those hours. And I think that was the reason for moving it to the police, because they could be called after hours. If we were to take another look at enforceability, the question then comes up, who is going to be able to respond after 5 o'clock during the weekends? And that's a good question. If it's not the police, who does it become? I think the other thing, too, to your point on the decibels, the building commissioner did not want to be responsible for buying a decibel meter, which I understand is not cheap, and then going through the extensive process of determining what is ambient sound, and then how do you determine the level of 10 decibels above ambient sound, because ambient sound can be different depending on the time of day, whether or not there's more traffic than usual, or a plane going overhead, or the wind direction, or any number of things can alter ambient sound. And so that was the reason in this for making the user responsible for proving that it wasn't above 10 decibels. Now, workable in practice, that could be a question mark that we should discuss.
So we have, yeah. So since we have a town administrator here, by any chance, have you seen this article that mentions the town administrator or designee may issue a license for use of amplified music at a specified time? Is that one of your powers at the moment? No, okay. Have you seen this before? I mean, yeah, okay. And I'm sorry to put you on the spot, Anne Marie. Is this something that's come up before? Permission to blast loud music?
Block parties,
Block
maybe?
parties.
Block
but,
parties.
I think that when someone requests a block party, if they talk about it, I think they're respectful of their neighbors. And it may be loud for a couple of hours, but it's not late night loud music. And most of the people at those block parties are the neighbors. So, but other than that, no, other than the institutions, and again, the institution question hasn't been answered yet.
Mhm.
Okay, Jonathan?
Looking at the language, the user may rebut the presumption by showing, etc. I wonder if, I have certainly never seen anything like that in what is arguably a criminal regulation. Do you crib that from somewhere? Is that tested language, or is that made up? I mean,
I think it was the drafter's attempt to figure out a way of how to keep, the town from having to figure it out, as I said. So then if the town's not going to figure out, the person who's blasting the music should have a way of saying, no, it's not too loud.
Well,
So it was an attempt to put a standard in there.
I think it's very clever. I don't think it would withstand court scrutiny. It's very, that's pretty vague. So that's why I asked whether you had gotten the language from somewhere where it might have been tested by a court. Because I don't do this sort of work, but if I did, I think it'd be a lot of fun to take that one in front of a judge.
That's a fair comment.
I mean, don't want to rain on your parade, but I really don't think that would withstand court scrutiny. But as I said, I do think it's wonderfully clever.
Great. Lee Michael?
Emily, I'm seeing a lot of question marks around this particular article and wondering just how many more there might be that we haven't vetted yet. And I'm wondering how you would feel about the committee voting to send this back to the planning board for further study, given that we haven't heard from town council and that the police chief has asked for more time and preliminarily said that he's not in favor of the article as drafted now.
I think one of the advantages of the warrant committee process is that there is that chance to vet the articles before they go down to town meeting and say whether or not you, as sort of the representatives and the people who advise town meeting on how to vote, if you're starting to spot problems that you feel are problematic at town meeting, first of all, I'd appreciate you telling me what they are so I can take it back to the board members. But if you think tonight that that is your likely vote, then there may be time for me to take it back next Thursday and possibly appeal to we could do it either two ways. We could leave it on the warrant so that it gets discussed. It's not a particularly long article. And it might be interesting to hear from town meeting members as to whether they would prefer an amplified music only or if they would prefer the board to look at a full noise bylaw. I think that would be worth knowing. So we could either appeal to the Board of Selectmen to take it off the warrant completely, or we could leave it on with your recommendation to send it back to us for further study, but allow town meeting to have that debate about whether it should be amplified music only or a full noise bylaw. And as I said, I think that could be useful information. But I defer to you on your own recommendation, obviously.
Okay, Phil, just before I get to you, let me just clarify something. I believe, I may be wrong, but did the Board of Selectmen approve the index of articles last night? Okay. So this is in there.
Yes.
Okay, this is not going to be withdrawn.
So then we would go for that second option and see what town meeting has to say about.
Town meeting doesn't have to follow the recommendation of the warrant committee.
Oh, of course.
We might recommend that it should go back, and they might say, oh no, we want this right now.
Absolutely. That is always an option. Now we want this
Okay, we got
now.
a problem.
So, if you were to recommend that it be referred to planning board for further study, I would certainly continue to follow up with town council, because there is always the possibility that town meeting will vote a different recommendation. So I would still continue to get answers to the questions as far as the legality of institutions being involved, whether or not we could add penalties on the floor of town meeting or before that, and the other questions you've come up with. So it wouldn't stop with your recommendation tonight, so.
Well, pretty much if we recommend that the subject matter of the article be referred back to the planning board for further study, we're probably not going to take it up again until you bring it back to us.
Oh,
Okay.
you wouldn't, but I would still have to be able to address town
would
meeting's
be-
questions, so
it would be
I
nice
would
to know.
continue to look at it, yes,
Right,
absolutely,
and it would be nice to know.
yes.
Phil, go ahead, sorry.
Yeah, Emily, when you speak to the town council about the Dover Amendment issue with respect to this, would you find out if you, unless you know already, are educational institutions covered by the Dover Amendment exempt from the state noise regulations?
It's a good question, I don't know that.
Because if you look at the state regulations, there is protection afforded there unless the noise is coming from a permitted event.
Mm-hmm.
I don't know, for example, does Curry College get a permit from the town when they have an event which is going to create noise? Are they not required to get a permit from the town? Presumably, if they're exempt from that, they may not be required to get a permit. But depending on the answer to that question, there might be more protection from the state noise regulation than we're currently enjoying. So.
That's a very good point. I actually was looking at the state noise regulations on something else, but I didn't think to apply it to the Dover Amendment, so that's a great question.
So, does everybody have any questions about this amplified sound article as it stands now? Mike?
I'm just, I went to the planning board's meeting and I saw this giant agenda with all these complicated things that were being discussed. And it made me wonder, why is the planning board doing this, bringing up this question? Should it be some other group of people? And I happened to go and find another municipality that had a noise ordinance which ran on and on and on. And today at the Rotary Club, I heard from another town where they talked about leaf blowers for 2 hours at town meeting. They generated a lot of noise. So you said we have to say no to this, recommend you vote no, recommend we send it back to the planning board. Could we recommend to send it to somewhere else, to like the Board of Selectmen, who are, I mean, I don't know that much about town
Only
government.
after there are
Even though I've
5
been in
of
town
them.
meeting
Come
for a
on.
long time, I haven't been paying that much attention. The general bylaws, it seems like it shouldn't be the planning board. Don't they do the zoning?
We do the zoning. Anybody can propose a general bylaw, so, and this had initially been, in fact, I've proposed one myself, which went through ages ago. But originally this was meant to be a zoning bylaw, which is why it was under the planning board. And then as we looked at it, we felt it would be more appropriate as a general bylaw rather than a zoning bylaw.
So my
Different
question to you is, would
enforcement
you like
issues as
to,
well.
I mean, besides adding 3 more months to the calendar, so you have a 15-month year to get all your work done, would you be okay with like moving it to some other committee or something?
I
keep
think your
going?
other logical committee would be the Board of Selectmen, of course, but they may have a few extra things on their plate these days. So, you could refer it back to the planning board potentially, and we could delegate it onward. There will be a master plan, there is a master plan implementation committee. We're seeking volunteers as part of the town's process for seeking volunteers for committees. So that will be up and running relatively soon. So that's a possibility. I think there's a new committee on disabilities as well, is that correct?
It's not new, it's just been
Revamped.
Yes.
So I don't know if that would be an appropriate one or not.
Actually, I've been writing these down, the names of all these committees. I'm kind of losing track of the committees.
So,
Disabilities and selectmen and a
yeah,
bunch
I
in
mean,
between.
we originated it, so it makes sense to send it back to
Send it
us.
back to
But
you.
if you
I
see
just
another
sympathize
one.
with your workload.
So if you go to the website and punch the button for committees, you get them all.
Yeah.
Um, There seems to be some talk here and there about a bylaw review committee. Is
Mhm.
that something we have or is being proposed by the Town Government Study Committee or
I'm sorry, bylaw 4?
bylaw review, all the bylaws of the town?
Yes.
Maybe also as a body that
I
might
believe
take
we
up
passed it at
things
the
like
town
this.
meeting.
Didn't we do that?
But
Yeah.
it wasn't going to include zoning
It was
bylaws,
just-
is
No,
that correct? It's just general?
we didn't
Yeah.
want to,
General.
we wanted to exclude that from the beginning.
Mhm.
We wanted to focus on the non-zoning,
Makes
general
sense to start
bylaws.
with the general and then move to
And the other issue was that the makeup of the committee might be a little different. Once you get into some of the other bylaws, it required a certain kind of expertise that might not be necessary for the general bylaws.
Yeah, I think that makes a lot of sense, so.
But they wouldn't be the body to send this kind of assignment to.
No.
They might.
I move that we recommend the subject matter of Article 7, amplified music, to the planning board for further study.
Second.
Any further questions? Nope. All in favor? Okay, thank you very much. Okay,
Great.
well, that was the easy one, I guess.
I will pass that back.
Thank you. Okay, so now, Article 8. What can I say about Article 8 first? Article 8 is sort of a short, not particularly threatening article. That, I found the more I looked at it, the more I didn't understand what it was trying to do. I'm a lot more comfortable with it now. I think I know what's going on here. But I'd love to hear from you, Emily, what is the history of the motivation behind this article?
So we had someone who appears in front of us on a regular basis come to us about a year and a half, 2 years ago, suggesting that we might want to look at the problem of houses that are currently non-conforming under the zoning bylaw, and who wants to have an extension, primarily an extension, or make certain other renovations, but are required by the building commissioner to go for a variance because they are non-conforming with the current zoning. And this produces a hardship for them in that the requirements for a zoning variance under the ZBA are actually pretty strict. You have to have some sort of issue that means you can't comply with the zoning. It could be a soil condition, it could be a topographical condition, but some sort of specific requirement. So the bar is quite high. So this is an attempt to take it out of the variance process and allow the ZBA to grant a special permit for that. So for example, say you have a house in Residence C that is too tall, and you want to put an addition on it. It is non-conforming because it's too tall. So you're required to get a variance even though the addition of this extension isn't changing that height nonconformity at all. So the idea is we'll take it out of the variance because the fact that it's too high does not meet the high bar set for a variance. So we'll take it out and allow the Board of Appeals to give a special permit that allows you to do the extension if you meet certain conditions. And one of them is you go no higher than the existing dwelling, that you're not going to cause an adverse impact on your neighbors, that you're going to be consistent with the neighborhood and the context, and that what you're trying to do is reasonably necessary. And part of this, the reason people are putting extensions on their houses, is that people live differently than they used to live. It used to be that you might have multiple children to a bedroom, one bathroom for the entire family, much smaller living spaces, living rooms and kitchens and so forth. People don't live like that anymore. You tend to have more bathrooms one bathroom per bedroom or every other bedroom. You might have a great room, you might have a sunroom. So the idea is to allow people to change their living spaces, make it more compatible with how we live today and more compatible with the market, but not allow them to have to go through an undue hardship in order to do that. So that is the genesis of this article.
Great. So a large part of my difficulty sometimes looking at zoning articles is the terminology.
Yeah, yes.
Okay. So for instance, this article says, is titled non-conforming,
Mhm.
and then you get down in the middle of it and says the non-compliances.
Ah,
And then you go, okay, all right, I think they mean the same thing. I think they're interchangeable, but I don't know for sure.
the
Okay.
fact that you're not compliant means that you're non-conforming.
Well, in the English language,
Say
yes.
that 5 times fast,
The English
yes.
language, absolutely, but sometimes, you know, there's zoning jargon, or
Right.
legal jargon. Anyway, so, and then, of course, most people, unless they've been through the process, wouldn't know what the various requirements for obtaining a building permit through a variance process
Right.
are versus a special permit. So once you understand a little bit more about that, then you can come to a greater understanding of what this might do. As far as our building inspector, his job is to get people building permits within the law. And, and my understanding is that the law itself has been confused by various cases that have come down that have seemed, and here's where I'm on real shaky ground because I'm not an attorney, but the cases seem to have influenced our building inspector to suggest that people who can't get a building permit as a matter of right go through the variance process, because the case law would suggest that our current Section 4 in the zoning bylaw for non-conforming uses is too broad and too easy, and that it needs to be toughened up in order for it to be a legitimate special permit process. So, you know, you hear one thing from one person and something else from somebody else, and you go, Anyway, I did speak to Joe Prondecker, our commissioner, at length this morning. He does seem to feel that this could be a very useful item in getting his job done, and that the result of it would be that he would send more people, more applicants for building permits that were involved in a non-conforming situation for a special permit rather than a variance, if he had this language. And he also had two suggestions that we uncovered. One was that, you know, this is a measure of protection for a property owner who's faced with a situation, and it is true that anecdotally, probably more of these situations exist in Residence B or C district than in AA or A, but it's not entirely the case that they don't exist in AA or A, and he thought it would be unfortunate not to include Residence AA and A in the in this protection, because even though you might have a large house and a large lot, it might be jammed into the corner in some non-conforming situation.
Yeah.
So that was one observation he had. The other one, which we sort of came to rather late, when I asked him if Section 9C was the right place for this, he hadn't realized that was the destination. The zoning board had assigned it, and the planning board, and thought it would work much better in Section 4. And so we found a place for it, which is the subject of the handout that I gave you. Because he said, frankly, if I'm an architect from Uxbridge working for a client in Milton, and they have a non-conforming situation, I'm going to go look at the specifications for non-conforming uses, and that's Section 4. I'm not going to find it in Section 9 under the process for applying for a special permit. That would just be a little secret between you and me and building inspector. So he highly recommends sticking it into the statute, that he also says needs strengthening in order to pass muster and make it more possible for him to suggest a special permit process to address a situation rather than a variance. So I have mocked that up, and that's a possibility. We can also vote on the way we got it from the planning board, and we also certainly want to hear from the two attorneys we have who are more well-versed on this than we are, because we also may want to send it back.
Well, if I may, on the AA and A, that was actually a discussion at our public hearing. We went back and forth. There was definite agreement that we wanted to add B, because originally it was just a C. So there's definite agreement that we wanted to add B. There wasn't quite a consensus on A or AA, but we were also aware that it was going to come to all of you. So I think those who I don't think it would be a great surprise to the planning board members, since we've already discussed it, if that change would be made. And obviously, we're open to suggestions if it's better in a different section. So if that's what you choose to do, I'm happy to take that back. So, and other than that, I'm also happy to defer to the attorneys who are here in the audience.
This is now when we'll actually learn something.
Thanks.
Well, sorry, didn't mean it that way. In fact, the facts may exceed our curiosity here, but we'll find out.
May we both join you?
Please do. I'd like to welcome Marion McKettrick and Ned Corcoran, both residents of Milton. And I don't know who would like to start and how you'd like to dig into this, but
Do they have copies of this other one?
I don't have copies.
you don't.
I left the file here somewhere.
Here you go.
Okay, sorry. That one's, I think my printer ran out of ink.
Well,
They got it.
They have a copy.
You do?
Yeah.
They're all set.
I know we'd like to review the proposed amendment, but it will take some time for us to do that. So rather than try to look at it in front of you tonight, I just wanted to make a few comments, and I know Ned shares some of them. Ned Corcoran and I both represent applicants in Milton who go to the Board of Appeals. And it's common for the reason to go to a Board of Appeals to be because your house is on a pre-existing, non-conforming lot, or the house is a pre-existing, non-conforming structure, or it's both on a pre-existing, non-conforming lot and it's pre-existing, non-conforming structure. That means it was built before 1938 when we enacted zoning, or it was built before a change in the zoning bylaw that made the house no longer legal in terms of the way it was cited. Houses like that and lots like that are protected by the state zoning code, Chapter 40A, to a certain extent. And then there are a whole series of cases that interpret the state zoning act. And one of the cases in 2005 did change the way the state zoning act was interpreted and narrowed the interpretation in a way that it had not been interpreted previously. So what that case did was it said, if your house sits on a pre-existing non-conforming lot, if it's a residence, and it's otherwise conforming, it conforms with all the dimensional requirements, it conforms with the height requirements, if you propose a renovation or change to that house that changes the footprint or changes the size, the square footage, the SJC decided that that was an intensification of the nonconformity, and the only nonconformity in that situation is the lot, is that the lot is too small. And because it's an intensification, the SJC said from now on, those cases have to go to a local board of appeals, and they require a special permit. They can't just get a building permit. That was a change in some towns that didn't have local bylaws that already protected situations like that. But all the building commissioners across the state, including our own department, building department, started changing the way they treated applications because of this case. Because so many of these cases do involve pre-existing non-conforming lots, lots that are too small. We have lots and lots of them in Milton. And in recent years, it appears that most applicants have been required to apply by our building department for a variance, which is not a special permit. A variance says that you don't comply with the zoning bylaw and you want a waiver from the zoning bylaw. It requires a much more difficult showing. It's extremely hard to defend in court, and it's not often upheld when a case is appealed. Even if neighbors support granting it, if the variance is appealed, it's usually defeated, because in order to show or meet a standing for a variance, you've got to show that your lot is physically different from all the lots around it, and in such a way that it makes it a great hardship, virtually impossible for you to use the lot. So it's very different from special permit standard, which is that you must simply show that there's no substantial detriment to the neighborhood if you do whatever you want to do to your house. So that's the history. What happened was, when I started getting these cases in the spring, I decided to go to the building commissioner and ask him why he was requiring variances. And I did two memoranda. I reviewed the case law, I reviewed the town bylaw in section 4, and I reviewed the state section, state 40A. And he said that he wanted to take these questions to town council. He wasn't sure. He said it's a matter of great confusion among building commissioners. And I haven't received an answer back from the building commissioner on that. He has not yet, I don't believe, had feedback from town council. So that's the setting in which, for me, this particular bylaw provision was proposed in the summer. I already had an ongoing dialogue with the building commissioner. I had talked to Ned Corcoran. He's another attorney who represents a lot of people before the Board of Appeals. We both agreed it was a problem, and we didn't think it was correct. But we couldn't do anything about it, because what we need to do is to get a case. You know, we represent clients. We take it to the Board of Appeals. We want to get an approval. And we take cases that we think are good cases and ones that should be approved. So we have to apply for a variance on behalf of clients. And we have to hope that the variance is granted and not appealed. Because if it's appealed, it's very unlikely that it will be upheld in many cases. So there needs to be a solution. I'm not sure what the proper one is, but if there's an amendment to the bylaw, providing it's done to section 4, which is where we talk about pre-existing non-conforming uses, and providing the language makes it clear that in this situation, consistently with what we've done in the past in this town, that a special permit is required and not a variance, then I think it's a good thing. So I'm in favor of finding a solution. I'm somewhat, I'm not uneasy about the fact that we don't have a response from town council yet, because the question we sent to him was rather theoretical. It was based on a bunch of cases, and it basically said, my premise was, we don't need a change in our bylaw. We already provide, we're more lenient with applicants than 40A is, and a town is allowed to be more lenient. You can provide more protection under your zoning, but you can't narrow the protection that's the bar that's set by the state law. So I thought that section 4 already covered it. It said special permit is required in this situation. The only change is that with the new case, we all know now that with a pre-existing non-conforming lot, that if you add to your house, you might have to go get a special permit, because it'll be an intensification of the nonconformity. That stands. That case can't be changed. So I'm going to read this language. I hope it's a solution. You know, I hope it's clear and it provides a pathway for applicants. And I'm going to be happy to see that if it does. And if it's within the scope of this proposal to make this change and put it in 4A and not in the section that it was proposed for, then good. You know, that's what I can say to you. So I'm not necessarily in favor of asking you to recommend that this go back for further study, Because if you can solve the problem with working with the building commissioner and find language that he feels is satisfactory, and I'll review it, and if I have any comments, I'll get them right to the planning board and the warrant committee, that'd be great, because then we would have something to put before town meeting and have a discussion about and hopefully get passed. And I just want to say that the planning board has done a great job drafting the other bylaws that they're working on. I think they ran out of time in the hearing process. They spent a good amount of time in the summer going over them. And some of those bylaws are going to come up in a future town meeting, and the warrant committee should continue to study them, and I will continue to study them and provide comments to the planning board. So I don't think there's been any time, I think that a lot was bitten off, and it couldn't all be brought to fruition at this point. I think this particular bylaw, since it addresses a particular problem, would be great if we could find language that town council says is an acceptable amendment. And if the warrant committee is willing to back that, I think that would be wonderful. So,
Yeah, so I,
you know,
Ned Corcoran, I think I'm one of the reasons why there was so little time to do zoning during these public hearings, because I had 2 massive public hearings going on at the same time. One finally closed, and the other one hopefully will close next week. So the planning board did a lot, and I was the impetus behind, I think, at least Alex Whiteside drafting this bylaw provision. I took a different tack than Marion did, in that I proposed some amendment, some language that would have amended Section 4. I think Section 4 is the right place to put it. That deals with nonconformities. That ought to be the location that this language shows up in. I also agree wholeheartedly that it should apply to all residential districts, and should apply to all buildings, all dwellings that pre-exist 1938.
yeah.
Because, you know, what if you wanted to go put a dormer in the Eustis Estate? That house is non-conforming. It's 4 stories. You'd have to go get a variance or a special permit, at least, to do that. So I think it ought to apply across the board. The way I look at zoning, and I've been doing it now for about 10 years, most of this town is pre-existing non-conforming. Probably 80% of the dwellings or the lots, maybe that's a little high, but it's not by much, pre-exist 1938. There are dozens of subdivisions that were done around the turn of the last century where not a single lot complies with the dimensional requirements that zoning was enacted to cover. In Residence C, minimum lot size is 7,500 square feet. There are hundreds of lots that are 5,000 square feet or less, or 5,500 square feet. Most of Residence C doesn't comply with Residence C zoning. I live on Morton Road. Milton Hills, a fantastic neighborhood. I'm surrounded by non-conforming dwellings. I live next to a 1780 Federal. It's 3 full stories. Couldn't build that today. Couldn't build a Federal that's around the corner. Couldn't build the 3 Victorians that are across the street or down the road. You couldn't build my neighborhood today. And yet, to make any real modifications to those houses to address more modern living standards, you've got to go, under the building commissioner's current interpretation, you've got to go apply for a variance. A legal variance is legally impossible to prove, except in extremely rare circumstances. Because you have to prove that there's something about the condition of that lot. Either it's topography, it's too hilly, it creates a height issue, its shape, maybe it's trapezoidal or it's triangular and you run out of room to meet all the setbacks, or the soil conditions are such that you can't put a foundation in and you've got to move the foundation to a certain location. You've got to prove one of those 3 things exists, and it creates a hardship for your ability to construct a dwelling. Well, if there's a dwelling that's already there, how do you prove hardship? You can't prove there's a hardship associated with changing it. So I know that the Board of Appeals works very hard to try to sort of interpret the variance in a permit standard. That, well, you know, it's really not a hardship. It's not the hardship issue. It's really not a detriment. People around the neighborhood seem to support it. It's not going to be a negative. It's going to be a nice change. So assuming that nobody shows up to oppose it, they vote yes, and they'll grant the variance. But every once in a while, you run into a situation where one neighbor doesn't like another, and whatever that animus is results in opposition to a reasonable modification to a dwelling, and they have to vote no. They can't vote yes if the standard that's being applied is a variance. And so it leads to, in some cases, I call it neighbor-on-neighbor crime. It really makes it difficult. And it creates a lot of angst when, and I hear this occasionally, well, you know, we have a zoning bylaw. Zoning is what it is, and you should have known that when you bought your house. You know, I bought my house in 1992. I had no idea that in 15 years later, when I had 3 kids who were teenagers, that I might need to modify that house to address the new living conditions. And 15 years later, was I going to think that I might need a variance if I was going to change the structure? No, and I'm a lawyer. Most people don't buy a house thinking that someday they would need a variance to make a change. So it creates really difficult situations among otherwise nice neighborhoods. When someone wants to make a reasonable change, if they have to go and establish the variance standard. Purpose for this, when I drafted it originally, was to clarify the notion that you don't need to apply for a variance. The planning board the Board of Appeals could grant a special permit. You don't have to find a hardship exists. They can simply say that there's no detriment to the neighborhood and that otherwise complies with the general intent of the bylaw, and they can grant the relief requested. So that's sort of the background. That was the genesis of why I moved this forward. In some ways, I suppose it could take business out of my own pocket, because if you don't need to get a variance, you really don't need to hire the lawyer to argue the hardship issue. You know, maybe it's against our interest, but I just think it's a more correct approach to the way this town might want to change and reinvest in itself. That if you're forcing people to go through a variance process that makes that difficult, I think the better approach is to go through the special permit process. So I understand where Marion is and her conversations with Joe Prondak. I haven't had, I haven't taken it in the same direction, but I do think that if this, and I'll study it as well, if the language works to create a special permit process that's clearer in the bylaw, then I would recommend that the Warrant Committee move forward with a favorable recommendation to town meeting. It might be there's some further minor modifications that want to be taken up with this, but I think it's an important enough issue that that the language needs to be clear, that the building commissioner has a clear sense of what the language is, so that when he's advising people coming into him with a set of building plans, that he's giving them the proper advice. And then the Board of Appeals and those of us who are practicing in this area are all working off the same sheet of music as well. So.
Can I just add, just to say, because I didn't say it when I spoke, I very strongly feel that if you are going to do this amendment, which I think is a good one, and I like the look of the language. It looks like it's been cleaned up. It's in the right place. It's doing what it was meant to do, but it should apply to all zoning districts. I don't think you should cherry pick one district and not another and say pre-existing non-conforming uses in one district, can do more than they can in another. Or I think that's not the way this.
So did I not include them all?
No, you did it that way. You did it right.
Okay.
I absolutely. I haven't had a chance to read it really carefully, but it looks like this is so much more what is needed, and it's in the right place. The language has been cleaned up a little bit. You worked with Joe Prondak on this, I gather, and I think that's the way to do it.
But I have to tell you that the only change I made was, or we made, Joe and I, in consultation, is to add the AA and the A.
And you moved it into 4A.
And to move it into the Section 4.
I would make one.
The other changes that you might notice were actually made by the planning board on Thursday. For instance, they took out the dimension of 3 feet as a variable. They took out the 300-foot mentioned in clause number 2 and substituted the words "the neighborhood," which
Yeah,
I
they
think
do.
affords greater flexibility.
with that.
I mean, 300 feet in the AA district isn't going to take you very far into the neighborhood. And I think there may have been another change. So Joe and I did check the references to the other sections to make sure that we didn't need another one to cover A, A, and A if we were adding them. So we're okay there.
There's,
So
the
two-
planning board took out 1 and 2,
Yeah.
so you put them back in. I mean, their recommendation
Maybe
is
when it
to
got to
omit
you-
1 and 2. So you might want to double check that with the
So if
planning
you
board.
look at,
The planning board took out 1 and 2.
if you look at the
Yes.
numbers, items numbered 1 and 2 do not cause an adverse impact on blocking light to windows, porches, decks, and yards. I thought they voted to remove that. And I thought they voted to...
left in 3 and
And I
4.
thought they voted to remove the second proviso.
Really?
Yeah.
It's-
Because we were
it-
sitting at the table when they did it.
Okay.
And the other thing I would suggest is modifying, changing the word non-compliances to non-conformities, because I think that's a more correct word.
Well, I was wondering about that. I did put in a hyphen.
Yeah, it's,
Uh,
that
but-
was not
but-
my language. It's a non-conformity, it's something that's
Right.
non-conforming. currently, it's
Non-conformity
not-
as opposed to non, that would be
not
fine.
non-compliant.
I'm troubled about the clause 1 and 2 because the text that I have is what I received from the planning board, both as a PDF and as a document.
Bill
So
Clark is here, and so is Emily, so
So-
they can answer that.
I'm actually going to
So
ask,
so the reason why we...
can you hold on just a second?
I'm sorry.
Yeah.
Tom, Pilla, I'm going to ask for a 2-minute timeout. I want to get clear on the language, and I need a break. Thank you. I'm sorry.